In May 2015, the Administration of Criminal Justice Act, ACJA, was signed into law as a revolution in the criminal justice arena because the criminal justice system existing before lost its capacity to respond quickly to the needs of the society. The ACJA has 495 sections divided into 49 parts, providing for the administration of criminal justice for related matters in the court of the Federal Capital Territory and other federal courts, and with respect to offences contained in the federal legislatures. The John D. and Catherine T. MacArthur Foundation is providing support to the project on the implementation of and compliance with the Administration of Criminal Justice Act 2015 as part of the Foundation's On Nigeria grant program. The Nigerian Institute of Advanced Legal Studies is one of the implementing institutions of the grant program. The project, which is to run for 3 years, is in its second year, with major steps being taken and the 3 different components already worked upon. A 2-day workshop was held in May as part of Component A of the project that had major stakeholders in attendance.
We just finished a very successful workshop on the implementation of the Administration of Criminal Justice Act. This workshop, which started on Monday, just concluded this afternoon. We had in participation 30 law officers from Oyo and Lagos State Ministries of Justice, 5 judicial officers, 5 magistrates. In attendance at the opening ceremony was the Chief Judge of Oyo State, my Lord Honorable Mr. Justice Amin.
The Administration of Criminal Justice Act 2015 is an improvement on the old criminal procedural law. Unfamiliarity with the new law on the part of key stakeholders such as lawyers, judges and support staff has led to frustrating results in its application. The law is meant to check the rising wave of crime, speedily bring criminals to book and protect the victims of crime. But delays that still characterize proceedings and the level of judicial rulings that are inconsistent with the Act shows weak appreciation of the Act.
We wouldn't have been able to do all this without the support of the MacArthur Foundation. It's a support that's going to run for 3 years. We are in the second year. We obtained the grants in 2017.
The project aims to support the implementation of and compliance with the ACJA through activities that will deepen understanding of the Act and improve the management and flow of criminal proceedings, including the prosecution of anti-corruption cases to which the ACJA applies. By increasing knowledge and providing practical tools for stakeholders through workshops, review bulletins and case digests, the project will enhance nationwide familiarity with the provisions of the ACJA, which are to ensure that the system of administration of criminal justice in Nigeria promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crime and protection of the rights and interests of the suspect, the defendant and the victim. Improve expediency in the handling of anti-corruption cases by reducing opportunities for delays in proceedings and promoting accountability. The ACJA has the potential to significantly boost anti-corruption efforts through more effective investigation and prosecution. Implementation of the ACJA can help to modernize the justice system, close loopholes, and provide a common legal framework. This project complements the efforts of governments and other stakeholders in the implementation of the ACJA.
The Institute's concern centered on 3 major aspects. 1, to organize workshops in order to deepen understanding of the ACJA. And the second component of the Institute's project relates to the development of tools, particularly the development of rules and guidelines that will aid implementation. The third component relates to the publication of bulletins and case digest. All these three components within the institute are manned by three different committees.
In collaboration with MacArthur Foundation, have been working on this to ensure that the Act is effectively implemented. Now, one of the major milestones we intend to achieve is to ensure that one, the Act is effectively administered. Two, that the issues of case management are properly handled, and of course, justice to the people generally.
Component A. The first activity under the MacArthur project on implementation of and compliance with the ACJA is capacity building training for major administrators and stakeholders of criminal justice in Nigeria. This project was carried out in collaboration with the National Judicial Institute, NJI, the Federal Ministry of Justice, Ministries of Justice in relevant states, the Nigerian Bar Association, FIDA, and Center for Socio-Legal Studies.
And of course, the major stakeholders are the judiciary officers, the prosecutors, and the defense lawyers. And the strategy that we adopted to achieve the objective of that committee are two. One, to organize training workshops for the major stakeholders. Two, to prepare training manuals that we use during the training workshop. As a matter of fact, we already had training manuals prepared. What the DG asked us to do, that committee, was for us to edit and enrich the manuals. But DG also emphasized to us that we should ensure that we work in collaboration with the relevant regulatory authorities or institutions in order to ensure that we have a fair and well-represented stakeholders during the training workshop. So we got in touch with all the stakeholders, the Federal Ministry of Justice, the various state ministries of justice, the various branches of the Nigerian Bar Association, and of course those were the major stakeholders, regulatory institutions. Of course, we also work in line with the Center for Socio-Legal Studies and the Federation of Women Lawyers to ensure that we got a reasonable and well-balanced participants during the workshops. Initially, our idea was to train the various stakeholders separately. In fact, that decision was also informed by the request made by the National Judicial Institute that we should train judges separately in the institute. The experience we had at the zonal level was that there was a strong desire by all the stakeholders for them to have closer interaction in order to really appreciate the challenges and of course the prospect of other stakeholders. So at the zonal level, we could not really maintain our initial plan of training the stakeholders separately. So we had like a sort of a joint training where the judicial officers, the prosecutors, and defense counsels were all in attendance. In fact, in Yola, we had representatives of prisons, attend the training workshop.
The aim of this is to achieve a reduction in the level of inconsistent applications, rulings, and decisions in terms of the implementation of the ACJA, as judges, prosecutors, and defense lawyers will be sufficiently sensitized on its provisions. Training modules tailored around corruption cases were developed for each class of participants at the workshops. There was a collaboration with the NBA and FIDA for the development of course modules for defense lawyers, while there was consultation with the Federal Ministry of Justice for the development of course modules for prosecutors.
Training modules tailored towards corruption cases were developed for each class of participants. There was a collaboration with NBA and FIDA for the development of course modules for defense lawyers, while there was consultation with the Federal Ministry of Justice for the development of course modules for prosecutors.
The training on the Administration of Criminal Justice Act 2015 by the Nigerian Institute of Advanced Legal Studies has been a rewarding experience. The Institute engaged stakeholders in the criminal justice system as resource persons. The training in the South-South geopolitical zone, which was held in Calabar in November 2018, had as a resource person the chairman of MBA Port Harcourt branch. When we moved to the Southeast in December 2018, we also had the chairman of Enugu branch and Okigwe branch as resource persons. When we moved to the Southwest geopolitical zone, we had our training in Ibadan. The chief judge of Oyo State moderated a session. In all the trainings we had in the 6 geopolitical zones, the state's directors of public prosecution acted as resource persons. In fact, we also had to engage stakeholders who were part of the drafting of the Administration of Criminal Justice Act 2015 as resource persons. We had Professor Akinsheye George and Professor Adedeji Adekunle SAN. In all of these trainings, we garnered so much wealth of experience. It was very rich, it was very rewarding, and it will improve the administration of criminal justice in Nigeria. We say thank you to MacArthur Foundation. Thank you for your partnership. We are grateful.
The module for judges was developed by NIALS at the Maiden Training Workshop of Judges in May 2018. The trainings are held in zonal clusters, that is, Calabar for South-South, Enugu for South-East, FCT and Kwara for North-Central, Kaduna for North-West, Yobe and Adamawa for North-East, Ekiti and Ibadan for South-West.
We've conducted trainings in the 6 geopolitical zones of Nigeria. We are currently working with the National Judicial Institute to see how we can integrate the training manual for judges into the annual training calendar of the National Judicial Institute. We engage expert resource persons, and the expert resource persons have used their expert knowledge to build the capacity of participants. Those participants have benefited from discussions, from the wealth of knowledge brought to bear by the expert resource person on topical issues regarding the Administration of Criminal Justice Act and the Administration of Criminal Justice laws of individual states. We've had resource persons take participants on issues regarding arrest, remand, bail proceedings and rights of detainees under the Administration of Criminal Justice Act, issues regarding prosecutorial responsibilities, interlocutory applications and adjournments, and timelines under the ACJA. We've also had resource persons look at and train participants on disclosure protocols, on forfeiture and seizure of assets under the ACJA. And we've also had a general overview of the ACJA. These are the focus of all the trainings we've conducted in the 6 geopolitical zones.
The only problem we had is that in some product zones, a few of them, some states could not attend, and because of the security problem we're having in the country. And that is where we are. That's the only, I would say, the only sad aspect of our experience during the training. And I hope that the Director General will be able to put a proposal to MacArthur for them to probably maybe make funds available for us to see why we can go back to those states and provide the training.
The participants of the various trainings have thus far benefited positively from training and have expressed their gratitude to the MacArthur Foundation and to NIALS. The second component under the MacArthur project on implementation of and compliance with the ACJA is to propose draft rules for adoption by the Office of the Chief Judge of the Federal Capital Territory under Section 490 of the ACJA. The mandate under this activity is the development of rules of court under Section 490 and other provisions of the ACJA, with particular reference to speedy dispensation of justice, case management and implementation of the Act generally.
Now, this has taken the shape of putting in place relevant rules of court pursuant to Section 490 of the Administration of Criminal Justice Act and other relevant provisions of the Act. in that requires that rules be made. And so my committee was charged with the responsibility of proposing rules of court to implement the Act. Now the committee is headed by the Chief Judge of the Federal Capital Territory, Honorable Justice Ishaq Bello, and I deputize for him that committee, as well as other eminent judges and juries across the country. The committee has been meeting, and the last of the meetings was one we held. In fact, the committee was inaugurated on the 9th of October 2018, and we started working in earnest to propose draft rules for consideration. Last month, we met in Kaduna to consider the proposals for the draft rules to see if they do meet the test of functionality, applicability, effectiveness, and so on, so that once the rules are signed into law by the Chief Judge, it will become effective. And so where we are right now is that those draft rules have been considered, inputs have been made by both users of the rules, particularly the judges and other members of the committee. And right now we're at the point of cleaning up the draft so that we can have the rules ready for consideration and approval of the Chief Judge of the FCT. So that is where we are in terms of the mandate of the committee and the work we have done so far.
The Institute is collaborating with the FCT High Court for this purpose. This activity is aimed at enhancing familiarity and skills in the application of the ACJA and the elimination of delays associated with criminal trials. Thematic areas identified for development based on the current state of the law, with the aim of curing any lacuna and giving constitutionally backed additions to ensure that the implementation of the ACJA is efficient and seamless. The thematic areas include arrest and criminal records, bail, remand, adjournments, disclosure, witness and witness expenses, award of costs, community service and non-custodial alternatives generally, parole, bail bondsmen. At the end, it is expected that the draft rules will be assented to by the Chief Judge of the FCT High Court, published and made available to relevant stakeholders in the criminal justice sector.
Now, in the case of the bulletin, we have published 2 already. One is on remand order, and the other one is on withdrawal of judges and lawyers from criminal procedures. What we try to do with this publication is to see how the provisions in the ACJA assist dispensation of justice in relation to when a judge or a lawyer withdraws from the process, or the remand protocol in the ACJA. We are hoping that with the case budget, any person involved in the administration of justice, especially the prosecutors, defense lawyers, and judges, we just pick our case digest and see what either the High Court or the Court of Appeal has held in regard to the interpretation of specific sections of the ACJA.
Component C was established to ensure publication and dissemination of the case digest and bulletins based on the ACJA 2015. To date, this component has been able to produce Volume 1 of the Case Digest and 2 bulletins on topical areas of the ACJA, namely Remand Order Protocol under the ACJA and withdrawal from trial of lawyers and judges under the ACJA 2015. The purpose of this digest and bulletins is to draw attention to the implementation of the ACJA in Nigeria. It is also meant to provide a blueprint for action for judges, lawyers, prosecutors, academia, and students, postgraduates and undergraduates with regards to criminal justice reform in Nigeria. Currently, work is ongoing with regards to Volume 2 of the Case Digest and preparation of 2 other bulletins in the ACJA 2015.
Component C. The third activity under the MacArthur project on implementation of and compliance with the ACJA is the development of case digests and bulletins on court judgments and rulings on the ACJA. The bulletins are to emphasize the lead role of the judge and the responsibilities of counsel in the reduction of delays and effective case management. This activity is aimed at advocating compliance with the ACJA and so improve accountability through the improvement of the criminal justice system. The case digest involves following up on judgments and rulings on the ACJA by high courts in Lagos State and the Federal Capital Territory, Abuja. Indicators under this activity include compilation cases, analysis of the judgments, publication of the bulletin, and dissemination. The first volume of the ACJA Case Digest has been collated and the 2 bulletins have been prepared and are ready for publication and dissemination. For the Case Digest, a desk review was carried out on the identified cases, and this enabled the detection of the ratio of cases, which is in essence the principle of law that is affirmed or laid down by the court in the particular case. The principles of law were later grouped into sub-themes and main themes. The main themes considered include objectives and application of the ACJA, arrest, detention and remand, autrefois acquit, bail, charges, compensation, confessional statements, criminal proceedings, conviction, no case submission, judgment, jurisdiction of court, miscellaneous provisions, plea bargain, pre-trial, search warrant, stay of proceedings, sentencing, among others. For the bulletin, 2 bulletins have been produced based on 2 topical areas, namely withdrawal of judges and lawyers from criminal cases, the position of the ACJA. 2. Remand Order Protocol under the Administration of Criminal Justice Act 2015, panacea for effective criminal justice in Nigeria. The ACJA case digests and bulletins on the same legislation will provide sufficient background and a reference point for prosecutors, defense lawyers, judges and case management in Nigeria. It will thereby further aid speedy dispensation of criminal cases. These documents are the first of its kind in Nigeria and highlights the way in which the judiciary are amenable to reform of the criminal justice system in Nigeria through the provision of the Administration of Criminal Justice Act, ACJA 2015.
Monitoring is a systematic collection of data to assist us in knowing what we are achieving under the project, while evaluation is a periodic collection of data to help us know and determine what is being learned and what part of the project is influential and why it is so. The gathering of information is necessary. That is what we do in the M&E unit. We gather information, we change it into data. This is necessary for the purpose of accountability and as well as getting feedback from the activities in which we are working on. Now, in M&E department, we have a theory of change. The theory of change contains the activities under the project, the activities we are carrying out, and it contains the people we want to influence, it could be the institutions that we want to influence, and also the results, achieved, the results we seek to achieve, and the results actually achieved. We have the M&E plan as well. The M&E plan helps us to monitor the activities under the project, to ensure the collection of information is designed in a way to examine all the results of the activities carried out in the project and how these activities or the results will be assessed.
Thus far, we've had participants who have expressed their gratitude to the Institute and also expressed their gratitude to the MacArthur Foundation for providing the grant that has enabled the Institute to conduct this project.
Well, I thank the Institute. They have done a very good job. For them to bring us here and for them to be able to keep the judges here, they've gone a long way. It's not like us to sit for too long, but somehow the program has been enjoyable to us. We thank them and appreciate them.
I would have loved for other stakeholders to have been present, the prison officials, the police, most importantly, to be here, because we highlighted lots of innovations and how to go about them procedurally. So I would just like to implore that at the next workshop, we can involve all the stakeholders. This will be great. Thank you very much.
I appreciate the John and Catherine MacArthur Foundation as well as Nigerian Institute of Advanced Legal Studies for doing this, and I hope that they do more of this so as to enable people to get the most out of the Administration of Criminal Justice Act and the Administration of Criminal Justice laws of the different states. Thank you.
The Nigerian Institute of Advanced Legal Studies is very proud to be associated with this project, and we are indeed grateful to the MacArthur Foundation for its support.